everyone. My name is Sylvia Ugolini, and I'm Principal Director, Planned Giving at Concordia University. I'm a lawyer by profession and estate and financial planner, and of course, Planned Giving expert here at the university for our alumni. We have with us today an alumna who's very dear to us, who's volunteered time and time again, Maître Nadia De Riggi, who's a notary here in Montreal. Quite close to the Loyola campus, not too far, so easily available to all our faculty and staff as well. And we're going to discuss today what could be elements of value for you to consider when looking at estate planning. Perhaps things that might enlighten you, correct some perceptions that may not be true, and help us along the way of planning, so that we can ultimately achieve what we want for our family and heirs. We're just wondering, can you tell us how much has changed during this pandemic in terms of what you are seeing with your clients and the whole area of will planning?
Thank you for having me. We've definitely seen a big change in our practice here in the notarial world, and in how the pandemic has shaped our clients' needs. And we're noticing that people are quite motivated to get their documents drafted and updated now that we are living through this pandemic. And so there's a greater sense of urgency happening, and a greater sense that people really want to make sure that their affairs are in order.
And we know that Canadians often procrastinate about this whole procedure of making the will. In fact, according to a 2018 poll from the Angus Reid Institute, 51% of Canadians do not have a will. According to, why is that generally?
I would say that clients who procrastinate to have their wills drawn fall into one of three categories, or have one of three beliefs. And the first being that clients falsely believe that will is not necessary, given their personal situation. So, for example, someone who's married may falsely believe that they don't need a will, or that it won't protect them in any way, that they're already protected enough. A second main reason I would say is that clients believe that perhaps it's too complicated. And so just the thought of having to work and gather information and list out personal effects is just a huge deterrent for some people. So there's that aspect as well that may keep clients away from coming to see us. And I think the third reason is just the idea of discussing, discussing what would happen if you pass away, or even the thought of leaving behind your loved ones it's not a pleasant one. And for some clients, it's difficult enough that they just don't want to face that reality. So they don't want to come in, they don't want to talk about it, out of sight, out of mind.
Can you tell us what the implications are of not having a will, and what the benefits are of having the will drafted?
So in Quebec, if you don't have a will, it is the civil code that's going to determine who your legal heirs are, and that will be based on your family tree. So you'll have no say, or your family will have no say on how assets are divided. Not only that, but if in that family tree you leave vulnerable family members, such as incapacitated family members or minor family members, you'll have no safeguards in place for them without a will. So a will is beneficial in that it gives you the control. It allows you to plan as much as possible to make your wishes known, and make sure that those people in your life who are vulnerable are protected even after you're gone.
There's also this impression that people with a marriage contract with a mortis causa clause, or people without children, do not need a will. I don't know if you can elaborate a little bit on that.
Yes, so a marriage contract is an interesting tool. It's one of many tools that we see and that we use to protect the family and the marital assets. But it's not all encompassing, so it may protect your spouse. It may protect your spouse to a degree, but it won't protect, for example, children or minor children. It's not a tool that would replace a will in its entirety.
So, for instance, if I have a spouse and I have children and I have no will, what would the devolution be under the Civil Code?
In a case like that, the children would inherit 2/3 of your assets and your spouse 1/3.
Supposing you have a spouse and you're not married, or you're not married or in a civil union, and you're common law and you have children, then what would happen?
So if you're common law and you have children, your common law spouse would actually not inherit anything. And so we see this quite often, couples that have been together for a very long time, but they're not recognized by the Civil Code as legal heirs. So that's a big one. That's a big reason why someone in a common law relationship would want to consider coming in to have their will drawn up.
And similarly, if you have alumni out there who are not married or who are common law and have parents that are living and siblings.
In that case, the parents and the siblings would inherit and not the common law spouse.
In other words, there's a benefit to really take care of one's affairs, and perhaps during this COVID time where we are spending so much in time indoors, rather taking that time to do, in addition to housework, some housekeeping in our papers. According to, are clients often aware of the size of their estate? In terms of size, in terms of potential tax liability, are they very prepared before they visit? Can you tell us a little bit about what you're seeing?
I generally have two types of clients. The first type of client being a client that is fully aware of everything that's going on. They have everything in order from A to Z, well organized, and they come in and they know exactly what they have, the size of their estate. They've already discussed with their accountant what the tax liability would be. And I would say that represents maybe 10% of my clients. The other 90%, I would say, have a general idea, but not a specific idea. So they perhaps haven't investigated what the tax liability would be. They may not know, they may not remember where they took out their insurance policy, with what company, or who their beneficiary is. So I think that's the norm. I definitely fall into that category as well. I'm guilty of that. But in general, that's it. Clients come in well prepared, but with maybe some homework to do after they leave.
What are the costs involved, and what are the costs of not making a will, and how many visits are sort of encompassed in this process?
We don't have standardized pricing. So for a notarial will, you'll be paying anywhere between $300 and $500, give or take, depending on the type of will. It may be more expensive. Versus not having a will. So coming in after a loved one has passed away involves a lot of investigative work, a lot of covering the details that were not covered because there's no will. There's a lot of time involved in that. And I would say that you're looking at a minimum of 10 times the cost of having the will drawn up, minimum. And also not only the cost, but the time involved. It's much faster when you have a notarial will to have access to the assets, access to the contact people at the bank, the financial planner, and so on. In terms of appointments, to draw up a will, it's generally 2 appointments. The first really to gather information, to start the discussion, and the second to come back and sign the will. Now, there's obviously discussion that happens between the two appointments. It's not necessarily an in-person appointment. We're seeing a lot of online now with the pandemic or over the phone. But in general, as a general rule of thumb, 2 appointments.
Nadia, how can people best prepare for their first visit to you? What documents should they have sort of gathered together for this visit?
For a first visit, it's always important to bring 2 pieces of ID. That's the obvious one, their social insurance number. But besides that, they should have with them things like their marriage contract, if they have one, marriage certificate. I will also be asking them things like whether or not they have registered investments, so they could bring with them their RRSP statements, any other statements of investments. They could also bring with them their proof of life insurance so that we can have a look and see who the designated beneficiaries are. And also they could bring with them titles to any property that they own, so title deeds to a house. And if they don't have the deeds, or if any of that seems too much, just a general list of these items is sufficient to get started.
Would you say that people are rather surprised to see how much tax liability their estate can be exposed to?
Yes, in general, people are surprised, and I encourage them to dig a little deeper and really sit down and work out the numbers, either with myself or with their tax advisor. But yes, in general, they are surprised.
Nevertheless, there is tax liability in Canada due to the presumed disposition of assets. Are people very much aware, or are they surprised to find this out when they're looking at the disposition or distribution of assets for their heirs?
I would say that in general, people are surprised. They're not aware when they come in of what the exact tax liability is. And so that oftentimes that number is surprising to them.
Liquidities can be an issue as well, and we would not want people, heirs to have to sell off assets at fire sale prices. So I think that people sometimes make the case for insurance when liquidity is necessary, or the aspect, of course, I come from the planned giving office here at Concordia, and we often discuss a charitable gift to donors who are attached to the university who would like to do something meaningful. Would you speak a little bit in terms of the deferral or elimination of tax when one resorts to a charitable bequest?
I think there's a definite place for charitable giving in the drafting of wills. We often see married couples who use the spousal rollover as a way to defer tax, or young couples with children, dependent children. So they may use that as well, the bequest of RSPs to their dependent children, to defer the tax. But what many people are not aware of is that they can use a charitable donation as a way to cut the tax liability of the estate. And so I definitely think that it's an interesting option for families, for couples, also for clients who maybe don't know who to leave their assets to. That is the reason why they haven't come in to write their will, because they don't know who to leave their assets to. So we like to encourage clients to look at charitable giving as a viable option, an excellent option actually to deter some of the taxes.
Of course, we're not predicating disinheriting children by all means. Where number one, we would, people want to take care of their family or their friends or their dear ones. But would you say that this is something that is, firstly, does it necessarily take a lot away from the estate when you look at, for instance, an asset like RSPs or RIFs, where despite the rollover to the spouse that's allowed, on second to die, or if the person's alone, 53% goes in tax. So what would you say in terms of percentage that could be taken away from the estate when such a strategy is looked at?
Well, I think when we're determining the percentage, we're going to want to look at the whole picture. So how much is invested in RSPs? How much is invested in non-registered investments? Is there an insurance policy that's payable to the family? and we can set it up so that the registered investments perhaps are given in a charitable donation, and the non-registered investments to the family. Obviously, it's very case specific, but we'll want to look at the whole picture in order to determine the best course of action.
In your experience, do professional advisors speak to their clients about philanthropy? We have various studies that show that the advisors themselves think they do, but the clients are saying that they don't. So I'm really wondering whether your experience with clients shows this kind of discussion in Canada. Is it widely discussed, or is there a need to enhance awareness?
I would say there's a need to enhance awareness, that's for sure. In my experience, if a client comes in and they have a large family, we have tendency to not even explore the option of charitable giving. Or we explore it when the client brings it up. But I think there's a place for the discussion to be had, for the options to be given, with an explanation of the benefits. Certainly, I think there's more room there for us to talk about it and explore that.
Can a codicil, for people that already have, let's say, the will in place, is a codicil sufficient to make provision for charity in their will or make other changes?
A codicil is an amendment to an existing notarial will that will be registered along with the original document. So it's really a tool that we use to make small changes. So, for example, if you want to change the name of your liquidator, we could do that with a codicil. If you wanted to include a charitable donation, it would depend on how the original will was drafted. So we would have to see if a codicil could be easily added to the document so that it makes sense, so that it flows well. But in the event that a codicil is not adequate, then we would advise to rewrite the will.
A codicil would not be as expensive as a full drafting of a will?
No, more or less, it's a half the cost of drafting the will.
Do you think it's advisable for people to discuss their will with their family and heirs?
That's an interesting question, and people have all different opinions rather on this question. I am of the opinion that if it's possible to have the discussion, I think it's absolutely necessary. I encourage it. I think that clearing the air, so to speak, going through things together with the family in advance is always beneficial. It avoids surprises. It avoids hurt feelings. It allows us to work through those hurt feelings while we're able to. And so I encourage it. I do understand that certain circumstances don't allow for that discussion to happen, and that's okay. I also understand that some clients are just not comfortable having the discussion and they feel that these matters should remain private, and that's okay too.
The whole notion of choosing a liquidator, it's quite a big responsibility. Do you think people tend to think of someone they naturally trust, or do you think that they have the default reflection to choose all their children because they don't want to offend anyone? What is your thought around the decision-making around choosing a liquidator?
I think often when clients come to see us to write their wills, they are thinking with their emotions, which is a normal reaction. But we encourage clients to consider, the tasks involved with liquidating an estate and whether that person has the capacity to undertake the role of liquidator. So, it involves everything from funeral arrangements to closing bank accounts. This is your contact person. So it's important to think of someone that you feel could manage with all of these big decisions, or if they're not able to manage themselves, someone that would at least be able to seek out the professional advice that they need to get the job done. So it's an emotional decision, but at the same time, you need to really consider whether or not that person would be able to fulfill the role.
There was a time where the testamentary trust was useful for income splitting as well as control. We know now it doesn't permit income splitting as such, but nevertheless, control is perhaps something that's interesting when you're dealing with significant amounts of money and perhaps young children or children that are mature. But as we see, there are different personalities in our family, people that are more spendthrift, less spendthrift. What are you seeing?
I am seeing a lot of young families actually who are during the pandemic thinking of drawing up their wills, and the main concern for them, the main focus is their children. And so we are using testamentary trusts for them, to be able to appoint someone to manage the money for their minor children. So it is a control, it's a mechanism where they can control the flow of assets to their minor children, control who it is that's in charge of those assets. So it's an interesting tool. It's an interesting tool for them.
Keeping an inventory, or prior to coming to visit, having an inventory of assets, debts, perhaps a statement also of liquidity, or what the estate would look like when in the event of death. So what assets would kick in, like insurance or what have you. Would you consider having a running list, a current list like this, useful? And if so, where should it be kept?
Yeah, I encourage clients when they come to see me to keep a running list of their assets. All that work that we've done to draw up the will, to take that information as a base, and going forward to update it every year. So where are your assets held? Who is your financial advisor? Who's your notary? Who's your accountant? Where do you have your investments and your passwords? In terms of where it should be kept, I am a firm believer that these documents should be kept at home, not in the safety deposit box at the bank, so that you maintain control. And I also like to suggest that clients tell at least one trusted person where they keep these documents.
Yes, I find that in our discussions with our donors about philanthropic giving as well, it makes it much clearer to have a notion of what their assets are, because sometimes they could be much more generous than they would think, and other times, and yet we want to ensure that they have a very, very enjoyable retirement, that there is a sufficient amount for the family. But as you said earlier, you need a big picture in order to really make informed decisions. It's advisable to have the big picture and deal with realistic numbers. And sometimes, I don't know what you think about this, but people are prone to think in terms of amounts. But with the passing of time, are percentages more recommended?
I think percentages lend themselves to an easier transfer in general. But again, here, it's very case specific. So I'll give you an example of clients who want to leave a specific amount as a charitable donation, or they want to leave a specific amount to their great-grandchildren or their grandchildren. That's okay. The only thing is you can't have only specific amounts in your will. So there'll be a combination of specific amounts and percentages. Certainly, I think percentages are easier to use.
In terms of funeral arrangements, Nadia, or sensitive issues as such, is this something that you think ought to be dealt with in the will? Is it something that should be discussed with family? We're looking at very unusual circumstances during COVID, where people are faced with these decisions and perhaps they never had that discussion. So where would the place for that be?
If a client hasn't had their funeral prearranged, they can certainly include their wishes for a funeral in their will. However, I like to remind clients that the will, if the discussion is not being had with the family prior to drafting the will is often read only after the funeral. So in order to ensure that your wishes are respected, you'll want to make sure that you've at least discussed the fact that you have funeral wishes within your will with someone in the family or the liquidator, so that they are made aware of that.
because I know of people who have either decided to go ahead with the restrictions as such or to defer or delay so that they can perhaps remember their loved one in a fashion that would be more commensurate to what they would have wanted. What would you say is the frequency required for will revision?
I would say every 5 years is a good general rule. But besides the 5-year rule, I would say every major life event. So if anything in your life changes, if there's a marriage, a divorce, birth of a child, birth of a grandchild, death in the family, it would be a good time to maybe take that copy of your will and have a look at it, and give your notary a call.
Well, I want to thank you so much for your generosity, Nadia. You've always been so generous coming out to speak to us and now to speak openly to our alumni in an area that really brings a lot of value and is of assistance in terms of putting our affairs in order. I hope that perhaps we can have you back maybe to discuss protection mandates or mandates in case of incapacity or advanced medical directives. But you're always such a charm, and we're lucky to have you as a neighbor, not very far from our Loyola campus. So once again, thank you on behalf of everyone here at Concordia.
Thank you for having me. It's always a pleasure.
Seeing my profession evolve from private practice to the estate and financial planning world and now the area of philanthropy, it's really rewarding to see all of this come together and to find ways in which people can put order in their affairs and achieve their objectives and ultimately leave a legacy in one or many ways, but achieve something very meaningful, all the while taking advantage of this professional advice and the tax laws that are available to them.